What I will try to do is look together with you at the division of responsibility in case there would be a responsibility for violations of international law. Then the question is actually who then would be responsible? Would it be the European Union, or would it be the member states, or would it be both of them, actually, all of them, that would be responsible? And how is that done? And there's a lot of academic research, especially in that area, on the division of competences and division of responsibilities between the European Union and its member states. But indeed, it has so far largely taken place in the area of CSDP missions, military missions, well, in other type of missions, and not so much the one we are dealing with today. So if you look at that particular research on operations, interestingly enough, the missions themselves are, of course, the question, of course, is what kind of missions are they? And to what extent are the military missions actually connected to the European Union and to the member states? Over the past few years, we saw a sort of move where at least the civilian missions, not so much the military ones, but at least the civilian missions got their own legal capacity. So in terms of claims, it has now become possible to actually sue the mission itself, at least the civilian ones, and not so much the military ones. And that is I think an interesting development that helps us look at these kind of questions. In terms of whether these missions, including Sophia mission, are actually EU missions or basically member state missions, I think one of the important things is always to look at the legal basis. All of them are most of the time based on Article 42, Article 43, and if you look at those provisions in the Treaty on European Union, you will see that it's always the Council taking the decision, right? So all those missions are based on Council decisions. It's an EU decision. And you see where I'm heading. I'm already heading towards my conclusion. But basically, the idea is that it's a Council decision adopted by the Council. Article 42, Article 43. Again, the Council shall adopt decisions, and the Political and Security Committee will be in charge. All of them being union institutions, union bodies, rather than that things have been handed over to member states. Also, in the case of Sophia, there's a very clear Council mandate, Council decision of 2015, laying down the mandate and also indicating the responsibilities of everyone involved in the mission. And as Achilles indicated in the beginning already, if you look at international law, if something goes wrong, who then would be responsible? Would it be actually the member states contributing to those missions, or would it be the Union? That's an interesting question. And in international law, of course, the conduct should also be attributable to a state or to an international organization. And there must be a breach of an international law obligation. In those situations, you could trigger responsibility of the actors. And the European Union has, to a large extent, used the sort of classical effective control element that is very important, of course, if in the law of international responsibility. Effective control meaning who actually is in charge of this operation? Is it the European Union that is guiding, or is it actually on the floor, on the ground? Is it actually the member state, or perhaps a member state that is in charge of this? And what we have seen over the past few years, also in legal doctrine, is that this effective control criterion seems to be moving towards sort of more competence-based type of thing. So who actually has the competence, and who is the competence to take the decisions, rather than who on the ground is actually taking the decisions or violating those rules? And I think again that is a very interesting shift that you can see. Connected to that is, of course, all these missions have these status of forces or status of missions agreements in which everything is very detailed, laid out in terms of who's responsible. And in most cases, member state responsibility or individual soldier military personnel responsibilities, most of the time is excluded from that. If you look at the SOFAs and the SOMAs in more detail. And of course, they don't want to be subject to the law of the particular state where the military mission is taking place. So they really like to exclude all their types of responsibility in that sense, which in the end normally also leads claims actually to the European Union. What the European Union has done in that respect is they invented this sort of called Athena mechanism, which is a separate type of instrument, a body almost, dealing with all the claims coming from people or entities affected by things that went wrong during a military mission. And that again sort of points to the fact that the EU seems to be dealing with these types of claims in a certain way. One of the questions is whether actually the court can say anything about that. Of course, the interesting thing about the European Union, if it boils down to international responsibility, we do have a court. We do have a court to deal with these kind of things. We do have a court that can deal with contractual claims. That is something else, but also with non-contractual liabilities. And that is interesting to see. And the problem actually is if you look at the case law, there's not so much going on in that respect. There's a lot going on in terms of claims from third parties on the basis of contracts, public procurement, etc. But not so much on the basis of actually non-contractual liability for military missions. Many of these things are dealt with through the Athena mechanism, or actually also on the ground by the military missions sometimes themselves, establishing sort of very small, simple claims systems on the basis of which a farmer, for instance, whose farm has been run down by a tank in a military mission, can actually go to claim their compensation. So it's difficult to find the answers in the case law of the court. Another question is whether national courts can perhaps do something. And we see development, at least in relation to the CSDP missions, the foreign policy missions, the defense missions of the European Union, that national courts see their responsibility there. We see a number of cases over the past few years where even national courts have been given a possibility to, at least in CFSP cases, to say something on that. So I'm just mentioning one case, the Rosneft case, which is very indicative in that respect. So who is responsible in the end? I would probably say that you could have this whole discussion on whether missions are actually organs of the European Union. Could we see them as organs? And I think looking at the decision making, looking at who takes the decision, in the end, I would probably say that the presumption is that the European Union as such is responsible. And only if you can rebut that presumption, you could end up at member states' responsibility. But I think that everything points to, in the end, responsibility of the Union as such. Perhaps finally, also to bring this back to the topics of today a bit more, if you look at, Achilles already indicated, it's probably not the case that the European Union is responsible, that human rights violations took place, either actively or in facilitating Libya in doing that. And as we just heard as well, the policy of the European Union is completely the opposite. It's not to facilitate human rights violations, no, it's to try and prevent them actually. So the European Union is very active, and its member states are very active in that field as well. So probably in the end there is no responsibility for those kind of things that are happening, for the human rights violations that are happening in Libya. The other question is, could the European Union or its member states be responsible, for instance, not intervening? The whole discussion on responsibility to protect. Could that be something that we could discuss? I think, again, it's quite difficult looking at what the European Union is already doing in this field to say that they violated the responsibility to protect the refugees that are in the camps in Libya. So again, this would learn, I'm running out of time, I know, but this would lead to the conclusion that also in these fields it would be difficult to establish an international responsibility for the Union or its member states unless you have very clear indications, for instance, that one or two member states on their own did something that could prevent something and they didn't do so or whatever. I haven't seen, also in the Amnesty International reports that we have seen, not seen any clear indications actually which would trigger the actual responsibility. So in conclusion, The division of responsibility between the European Union and its member states remains a very complex issue because of the division of competences between the two. But in the end, to the outside world, I would always say there is a presumption of EU responsibility. And in fact, I think that the European Union should act as a sort of portal for third states, not leaving it to third states to decide whom to address, either the Union or the member states. So in the end, we should have something of an EU responsibility, even in the case where member states would be responsible, just to facilitate the international responsibility system for third states. Thank you very much.